This is the most unconstitutional, undemocratic, unfair scheme that destroys the very basic structure of our constitution. Free and fair elections is the basic structure of our constitution. This scheme is neither free nor is it fair. It's not free because the industrialists cannot say no. It is not fair because in that process, the political party in power gets the maximum capital and the capital it wants, not for elections, for other purposes.
Yes, Mr. Bhushan, what do you have to say?
Yes. So the first argument of the solicitor was that because of these amendments, the volume of cash which is coming to political parties, which he says are maybe black money or is likely to be black money, that has gone down.
No, that's not his argument. He doesn't make a quantitative statement. His contention is that this was an effort which was made to bring into the accountable channels what was otherwise completely beyond the fold of accountability because the earlier schemes had not worked.
So let me just deal with that. Firstly, my lord, it did not close the cash channel. The amendment has left open the cash channels. The only change that has been made is that for getting income tax exemption, that 20,000 has been brought down to 2,000. That's all. Otherwise, donations up to cash donations up to 20,000 can be given to political parties and they are not required to be reported. Quite apart from the fact that actually 20,000 or 2,000 does not make any practical difference because all that the political party declares is, I have received X crores as cash donations, which are below 20,000. They used to say below 20,000 earlier. Now, if they want to avail of income tax exemption, they say it's below 2,000. So they say that we have received whatever, 100 crores, 500 crores by way of petty cash donations. Earlier, petty meant below 20,000. Now, petty means below 2,000 if you want to avail income tax exemption. Practically, it makes no difference in my respectful submission to the availability of cash to political parties or the ability of individuals to give cash to political parties. Practically, that 2,000, 20,000 makes no difference. Now,
that will not impinge upon the validity of the scheme.
Yes, I know. Lord, they are saying that this whole exercise was to bring down the element of cash in the economy. They say cash is equivalent to black money. The object of the exercise was to make political funding of parties to come more through banking channels rather than cash. This, they say, was the stated purpose of this whole bringing in electoral bonds, one of the stated purposes.
Mr. Bhushan, there will be slight difficulty. Even if it has not happened, probably the data may support you. The cash channel may not have come down.
Cash did come down. I'm not saying cash didn't come down, but the reason why it's important to understand why cash came down.
There are three, four arguments on which we want direct answers.
Yeah.
One is that the intention was to ensure that the money comes through regular banking channel.
Yeah.
There is a KYC required.
Yes.
Which is not there as far as payment cash is concerned. And also, even if it is coming through the bank accounts,
yes,
the KYC by the second KYC at the time when the bond is purchased is a second added advantage.
All right. Let's assume that that's there.
Number three, their contention is that as far as payment is concerned, the person who's made the payment is concerned, the need to know the name of the donor has been protected. The confidentiality of the donor has been protected.
Yes.
For 1, 2, 3, 4 reasons.
Yes.
And therefore, when you are examining the reasons, you will have to take into account what was the intent behind the enactment, and not by a counter argument, which may be. And there has always been a conflict between confidentiality and declaration. Or
so my lord,
both of them have their pluses and minuses.
to answer our argument that these changes defeat the citizens' right to know about who's funding the political parties because they introduce another anonymous source of funding. Now, the answer given by the solicitor to that is that, well, it had an objective. Now, these are two conflicting things. They say the objective was to limit black money or cash money coming to political parties or to reduce that. And therefore, we introduced these electoral bonds because many individuals or companies do not want to be known that they are the donors to these political parties because they fear victimization. So that was what the finance minister then stated. That's the argument also of the solicitor, that there was an objective behind this. Now, what I'm pointing out is that if the objective was to choke off cash donations have not been choked off.
But that was not the object at all.
Yeah.
The object, as the finance minister says in that article, and that's broadly an indication,
Yes.
was to add some element of transparency. That's what Mr. Jaitley said, that it will enhance transparency to a significant extent, and we would add two separate phrases which have been used. That's the point. You're right. In the earlier regime, absent this, it was purely cash based. You had those options, voluntary contributions, you had electoral trusts. But
not just that, you had direct check donations, etc. That is
a cash based scheme, an unaccounted scheme, proceeds on anonymity.
Yes.
According to you, they have continued anonymity.
Yes.
But
they have continued that anonymity
but
of
there is
cash.
but there is
well
one
as-
change.
Yes.
But there is one change.
Yes.
That the electoral bonds have brought whatever is contributed to the electoral bond in the form of accounted transactions within the normal banking fund.
Now the question. So that's the second limb of the argument, that this reduces black money flowing into political parties because it's coming through banks. Ultimately,
Whether it reduces or not, to my mind, is irrelevant to the validity of the scheme.
all right.
The scheme may be wholly unsuccessful, but it may still be a constitutionally valid scheme.
No, Lord, then that is no response to my original submission, which is that it defeats a constitutional right of citizens to know who is funding these political parties. That's a fundamental right which your lordship has recognized under 19(1)(a). And if what is being argued, that the object of this bringing in electoral bonds was to reduce cash and reduce black money, so to say, and bring in only accounted money through banking channels to political parties, if that's the argument, then I'm just pointing out that that's not entirely correct for the reason. Firstly, you can still give cash. There is no bar today which has been placed on cash. The only change that has been made is simultaneously.
But how do you put a bar on cash? It's a third economy. Much as you may impose a bar on cash, it's illegal. But you have a third economy.
That's the point, my lord, that it could easily have been done that all receipts of political parties, at least of political parties, will have to be accounted, whether it is cash or not. All cash also, any money being received, you could have done either of two things. One is to say the cash is totally prohibited, you have to take through banking channels. This is one option. The other is, even if you take cash, irrespective of the amount, even if it is 100 rupees, 50 rupees, even the RBI, when it dealt with this electoral bonds, when it responded to electoral bonds, they said that if your object is to make political funding go through banking channels, there are existing instruments of checks, drafts, bank transfers, etc., which are available. why are you introducing this anonymous instrument? This will allow, because as I pointed out, Lord, it's not that black money cannot come in through electoral bonds, though it will come in through banking channels. The example that I had given in my initial submissions was, suppose, as has been done, that you, by under invoicing, over invoicing, etc., you siphon out some funds, X crores or X thousand crores, to tax havens. From there, my lord, you have a company to which you have deposited. That's all black money. It's over invoicing, under invoicing money which has been siphoned out to those tax havens. You set up a subsidiary of that foreign tax haven company in India. It's a subsidiary under the FCRA changes. It was argued, my lord, FCRA is not in question here. But FCRA changes have been challenged in this very petition also, 2016, by which the availability of even subsidiaries of foreign companies to donate to political parties was brought in. And whether or not your lordship decides on the validity of that or not, your lordship have to keep in mind the fact that simultaneously that route was opened up. The route of subsidiaries of foreign companies donating to political parties was opened up. Now, what I am pointing out is black money can still flow through electoral bonds in this way. You have converted black money and deposited it into a tax haven bank account of some company registered in a tax haven. You then transfer that money to, you set up a subsidiary in India, transfer that money to a subsidiary in India. That subsidiary company, because you have removed the limit of 7.5% also, even if it's a shell company.
Mr. Bhushan, at a constitutional level, this argument won't wash. I'll tell you why.
I am only responding to what was argued, my lord. I am not.
This will not wash. This,
of subsidiary company.
this will not wash at a constitutional level for the simple reason that the fact that they have been unable to, or they did not, dry all cash sources of funding of political parties is not an answer, is not there is not a ground to challenge the validity of a scheme.
I'm not using that ground. I am saying that the response of the government to my grounds. What were my grounds, my lord? My ground was Article 1918 defeats the rights of the citizens to know the funding of political parties. Number two, my lord, it promotes corruption because it effectively legalizes corruption because it allows any company to give anonymous kickbacks, legalized anonymous kickbacks to the parties in power. And I pointed out that the evidence, there is considerable evidence to show that almost all the electoral bonds have gone to ruling parties. Vast bulk to the ruling party in the center, the rest to the ruling parties in the states. And virtually all the electoral bonds that have been purchased are in 94.5% in denomination of 1 crore and the remaining in denomination of 10 lakhs, virtually nothing below that. Therefore, there is good reason to suspect. And I gave two examples also. I'm not saying that your lordship should use those examples because those parties, those companies are not before us. But I gave those two examples. One company has declared officially that they gave those electoral bonds to ward off excise issues which had arisen with the government. The other company who has purchased electoral bonds worth more than 450 crores from their accounts declared to SEBI has been the recipient of several mining contracts and various other favors.
You already argued, Mr. Bhushan. You're in rejoinder.
These are all auctions. Mining contract
You're in the rejoinder now.
Kickbacks. You participate in all.
Don't re-argue your case.
I'm not re-arguing. I'm just pointing out that that's my argument. Now, what is the government's response to that? So how do they answer this question that this defeats the citizens' right to information? One answer that they have given, I was coming step by step. One answer that they had given was that there was a competing interest of bringing down cash or bringing down unaccounted money into the donations and finances of political parties. I am just answering that issue. The other argument that they have made is that there is a right to privacy. That's the argument made at the end. Firstly, my lord, the right to privacy doesn't extend to companies. It's an individual human right. Even in Puttaswamy, your lordship have laid down that that's an individual's human right. It's not a right of a company. So therefore, so far as those amendments which have been made to the Income Tax Act, to the Companies Act, etc., which anonymize donations by companies to political parties and remove the requirement of declaring who you have donated to or where you have spent this money, that right cannot be invoked for companies. The right of privacy cannot be invoked for companies. And even otherwise, my lord, if let's assume that there are some individuals who are giving this money, the question is, can those individuals claim a right to privacy which overrides the right to information of citizens? Even under the RTI Act, if your lordship recall, there is an exemption for privacy. There is an exemption for personal information. But that exemption stated that only that personal information which has no bearing on public affairs and which cannot be overridden by public interest is exempted. If there is a public interest override, even that information is not exempted. So in my respectful submission, my lord, that privacy argument cannot be used to say that my right to privacy about which political party I am donating to overrides the citizen's right to information, to know about who the political party is getting funded from. So that right, my lord, in a clearly would override, even if there is a right of privacy of an individual. Of course, companies don't have that right, but even if an individual has that right of privacy about donating what they have donated to political parties, in my respectful submission, that is overridden by the citizen's right to information. The other argument that was made was, again, on the basis of what the finance minister had said. It was argued that this is to prevent victimization. Now, firstly, as your lordship pointed out, the government would certainly know, or the party which runs the government can find out, look, this company had purchased electoral bonds worth 100 crores. We have not received anything from it. Therefore, obviously, they have given it to the opposition parties. And therefore, that much information which will still allow the government to victimize that company is always available with the government. Even if they do not use their control over the state bank to find out which company has given electoral bonds to which party. The argument that was made was that no, there is an elaborate system of protecting that information. It's very simple, my lord. Obviously, when a person purchases an electoral bond, he gives KYC, etc. The bank would have to record that this person or this company has purchased this electoral bond, and the number of the electoral bond would have to be recorded somewhere. Thereafter, my lord, when a party encashes that electoral bond, the number of the electoral bond which that party has encashed would have to be recorded. Otherwise, my lord, it would make it open for counterfeiting. And therefore, you have to record these two informations. So therefore, it's not so difficult. If the government wants, State Bank of India would certainly know. And if the government exerts sufficient pressure on the State Bank, they can come to know. Even otherwise, my lord, the government would know as to which companies have purchased electoral bonds worth how much, and that we have not got it.
So one point is, of course, you have highlighted the citizen's right to know. What is the next?
right to know that the sphere of the justification for victimization, etc., doesn't really apply. In fact, it's only the citizens who are being deprived of this information. Each political party would know, can know, and certainly the government can know. A citizen cannot, my lord, scan the.
Mr. Bhushan, I think point in rejoinder. Please.
And then, my lord, just two more things. There was an interim order, as your lordship saw,
Yes,
asking the
12th of
Election
April,
Commission. I am respectfully saying, because they are going to open electoral bonds window for this state assembly elections any day now. It can be open tomorrow, it can be open day after. And again, my lord, till today, till March 2022, electoral bonds that had been purchased were over 9,000, under 10,000 crores. Till today, I understand that the electoral bonds that have been purchased in this last 1.5 years has taken the total to 13,000 crores. Now, today, if they open the electoral bonds, again, in this assembly election, again electoral bonds will go. I am respectfully, my lord, requesting your lordship, even if your lordship does not stay the issue of electoral bonds after today, at least one thing your lordship should say, that it should be made clear to the parties who are purchasing electoral bonds that these may be subject to disclosure. Because this court has the power under the scheme also to seek information from the State Bank of India. And I am requesting, my lord, that at the end of this, if your lordships agree with us that this electoral bond is unconstitutional, etc., then your lordship should disclose as to which company has given to which party, etc. And even if that information has to be obtained from the State Bank of India. And that's why, my lord, I'm saying that at least today, because last time the same thing happened in that Election Commission appointment case. I had an interim application. I mentioned that interim application on Thursday, on saying that there is one post vacant of the Election Commission, and the court is proposing.
Except for the difference, except for the fact that after the 12th of April 19 order,
Yes,
when you moved a fresh IA for stay,
that was for that particular.
that stay was declined by the then
Yes,
judge.
yes, that was at that stage
Mr.
for
Bhushan,
that particular.
That's why I asked,
bond.
what is exactly your prayer? You asking for quashing of the?
Of course, I'm asking for quashing.
Just 1 minute. You asking for quashing of the scheme, or you want that a disclosure should be made?
No, I'm asking for quashing of the scheme.
Okay, therefore, you had to
scheme.
answer that question.
And in case your lordships.
Mr. Bhushan, just one more question.
Yes.
The scheme has one advantage. There's a KYC at least. You will accept that there's an advantage in that.
No, that's all right. If the anonymity is removed, I have no problem.
So therefore, you argue on that.
I'm saying I'm challenging the scheme because of the anonymity. Remove the anonymity, I have no problem with electoral bonds. I'm challenging the anonymity of the electoral bonds. So that is defeating the right to information of the citizens. So, so what I'm saying is.
So you are basically pressing for the entire scheme to be set aside, and you're also arguing that the amendment should therefore be.
The law that applies to a candidate doesn't apply to a political party. Why? What's the rationale? What's the basis, Madam, of coming to this conclusion? These electoral bonds are meant for a political party to be in power in perpetuity, because the amount of money through these means, which quote unquote are legitimate, will empower that party through capital to influence everything. This is the most unconstitutional, undemocratic, unfair scheme that destroys the very basic structure of our constitution. Free and fair elections is the basic structure of our constitution. This scheme is neither free nor is it fair. It's not free because the industrialists cannot say no. It is not fair because in that process, the political party in power gets the maximum capital and the capital it wants, not for elections, for other purposes. That's very dangerous. Incentivizing, and I'm come to the other main argument. Incentivizing, I won't take more than a few minutes, Malad. I don't want to trouble your lordships. Incentivizing the use of banking channels. Of course, you will get this legitimate money through banking channels. In fact, that's the perfectly rational way of enriching yourself. Perfectly rational way. But that's not a justification for empowering yourself. I can understand if there was a correlation between this and the election process, in which you must disclose how much you have spent, where you have spent. But that cannot be because it is the candidate who is fighting the election, not the political party. As far as persecuting the person who has been given the money by that party to an opposite party, they will be persecuted. But why will they be persecuted? Well, let me tell your lordships, just to tell your lordships what the reality is. A big industrialist who has enormous power will give it to all political parties. And the party of the center will never hold it against that industrialist. Because everybody's benefited. The system enjoys this money. Enormous capital to the party that is in the center and small little donations to the others. And everybody knows about it. It's not a secret. So there'll be no retributions that why did you give it to that party? Because you've also got the maximum. Why should there be a retribution? So this whole argument that no, there'll be a retribution, why have you given to that party? Supposing, Maharaj, I have got 100 crores. I get 100 crores, but the donation shows that he has given 500 crores. I know that 100 crores come to me, 400 crores have gone somewhere else. And if, Maharaj, for the 100 crores, the quid pro quo is 4, 5, 6 instances, Maharaj, then out of 400 crores, why should the retribution be more than just 4, 5, 6 instances? The same logic will apply. Same logic will apply. So why are you protecting those, Maharaj? And the most serious part, Maharaj, which I said earlier, that I will never be able to go to a court of law. What you're doing is giving a protection to corrupt transactions by not putting that information in the public domain, because I will never know. So, Maharaj, how do I move forward? Where do I go? I can't file an FIR because I don't know. I'll be subject to defamation. I can't go to court. I have under 156(3), I'll have to go to, I'll have to give some data. I don't have the data. So what court order are we talking about? Don't shield the process of corruption itself by allowing this to go on. If you want to deal with corruption, the first thing to do is to quash this scheme. This is the surest way for political perpetuity. Having said that, just 5 more minutes. Then, Maharaj, the respondents argue that EBS is a matter of financial economic policy. It certainly is not. It deals with elections, nothing to do with financial policy. In fact, the EBS and amendments on which it is based changes the very ground rules of the electoral process. The very ground rules, which negates any presumption of constitutionality and on the contrary requires heightened judicial scrutiny. That's the answer to that question of financial and economic policy. Economic policy in the bearer bonds issue because that way you can bring black money into the economic system and pay tax on it. This has nothing to do with it. 2, he said, they argue that making the identity of donors as an extension of secret ballot, the right to vote and donating of funds are distinct. The right to vote is secret ballot. Donation of funds cannot ever be secret. 3, he says there is no uneven playing field. I will demonstrate it to yourself that the entire field is uneven. 4, they say the respondent has distinguished ADR and PUCL on the ground that the information sought for in those cases already existed and just needed to be disclosed. In this case, Manoj, the only reason the information about the identity of donors is unknown in the present case is the structural design of the system. You have structured the scheme in such a way that it's unknown. So, Manoj, I really don't want to say anything more. All I can say is, Manoj, and Manoj, what is the public interest that is being served here? I don't understand what the public interest is. Public interest not to know, not to disclose. And who are you protecting? For what purpose are you protecting these people? You are actually protecting yourself because you know who has donated. It is self-protection, self-preservation, self-perpetuity. How can the public interest in protecting the identity of donors outweigh the public interest in the public's right to know? To be free from corruption. So politics, Manoj, as I said, it's impossible for us to get rid of free money, black money, Manoj. No country in the world has got rid of it. Let's be clear on it. All your lordships can do is to tell the government, this is not the way forward. You want to deal with it in a way that is transparent, that gives us the confidence that it is not for you, it is for the larger public interest. Thank you very much.
Thank you, Mr. Sibal.
Manoj, also, I would say, I filed rejoinder submissions already to his submissions, Manoj. A court master may just upload them. All that I have said to your lordships is dealt with that in about 12 pages. I'll give you a copy because I didn't want to, Manoj, take too much time to read them. There are others also. I'm deeply impressed.
Plus, the core of our challenge is to the
Yes, Mr. Sibal.
to the statutory provisions which prevent public disclosure. Plus, those are the statutory amendments. The scheme follows based on those amendments, namely amendment to Section 29C of the Representations of People Act and Section 182 of the Companies Act. Those were the public disclosure provisions. The scheme, once the public disclosure comes in the scheme, there is no real scheme to survive. Now, this is to answer my Lord Justice Khanna's question, what are we challenging? We are challenging those two statutory provisions because once that goes, the scheme itself collapses. The basis of the scheme is non-public disclosure. Plus, with that, I would submit why do we need in rejoinder 2 points only. Why do we need public disclosure? Plus, number one, as the US Supreme Court said, in Buckley versus Valeo, a political party may represent anything to the electorate. It may self-ascribe any label to itself to the electorate. But one of the best ways of determining what the party is about is where or who it is going to be most responsive to is where it gets its funds from. If that aspect itself is removed from the public domain, so a party can say X, take the money from Y or other interests, and the public has no way of knowing. So public information is necessary for voter to form its view into voting. That is a substantive right to vote, is an informed right to vote. And therefore that information as to who has given you money to, so that the voter can match what you are saying. Are you taking money? Are you a green party? You're claiming to be a green party, but taking money from oil interest. There are n number of examples. So that is one interest which is necessary. Second, the question fell from the court yesterday to the government that how will you prevent quid pro quo? Quid pro quo has been used by both sides very broadly. Let me just try and bifurcate it. One would be policy influence or policy capture. Strictly not corruption. Second will be legislative influence or legislative capture. Strictly not corruption either. The final stage would be corruption or bribery. The only, in my respectful submission, the only constitutional safeguard against preventing quid pro quo is in fact public disclosure. And one constitutional court in South Africa, I just want to place 2 paras. In rejoinder, normally I wouldn't place paras of a judgment. Only 2 paras because exact same situation arose in South Africa. And the Constitutional Court of South Africa has said that the only way to ensure that these other things, nothing can be removed in a polity is a complex space. Surely we can't expect a perfect world. But from areas or zones of influence to movement to zone of corruption, that can be prevented by public disclosure. Your Lordships will just have page 6654. 6654, volume 4. Volume 5, I'm sorry, my apologies. Plus, the case is titled quite aptly, My Vote Counts versus Minister of Justice. And straight away, para 40 at page 6653.
What page does this case begin? 66?
Well, 6653 is the relevant portion. Bookmark number 60, 60.
Yes.
This is volume 4 of?
Volume 5, my lords.
Volume
Volume 5. Plus para 40. As the court has it. The reality is that private funders do not thoughtlessly throw their resources around. They do so for a reason and quite strategically. Some pour in their resources because the policies of a particular party or independent candidate resonate with their world outlook or ideology. Others do so hoping to influence the policy direction of those they support to advance personal or sectional interests. Money is the tool they use to secure the special favors or selfishly manipulate those who are required to serve and treat all citizens equally. Unchecked or secret private funding from all, including other nations, could undermine the fulfillment of constitutional obligations by political parties or independent candidates so funded, and by extension, our nation's rightful place. Then thereafter, our freely elected representatives must thus be so free that they would be able to focus and deliver to their core constitutional mandate. They cannot help build a free society if they are themselves not free of hidden potential bondage or captivation. Now, para 42 is important. I'll read only from the third line. Only when there is a risk of being exposed for receiving funding from dubious characters or entities that could influence them negatively for the advancement of personal or sectoral interests would all political parties and independent candidates be constrained to steer clear of such funders and be free to honor their declared priorities and constitutional obligation. And that risk would enable by a regime that compels the disclosure of information on the private funding of political players. So, my respectful submission is public disclosure is the real check. Public disclosure is the real check. And therefore, from all the kind of things which happen in politics, from that to moving into the zone of corruption. And in a democracy, it's the public which tests the party every day. Plus, effectively, that is the biggest check. Plus, finally, an argument on confidentiality was made. A certain formulation of that was made on privacy. Plus, and a comparison was made to right to vote is a secret right to vote. And therefore, this by extension, you should have a secret right to fund. In effect, if I understood, that was the formulation. Our respectful submission is right to vote is your own exercise of franchise. It's the least level of participation as a political actor in a democracy. The minute your levels of participation starts increasing, if I want to fund and influence the system as a whole, of course, I cannot be claiming privacy or confidentiality. If I'm holding a public office, my level of confidentiality or privacy will be restricted to my family zone. So, this privacy, even in respect, of course, corporations don't have a right to privacy. It's Article 21 right, flows from right to life. So that is out. But even assuming natural persons who may be donating, their right to privacy can certainly, or right to confidentiality, whichever way we frame it, cannot extend to an area where they will now impact the entire political system and seek to do so secretly as a matter of right. Of course, it cannot be. So as we go up the system, in terms of our political influence, the proportionality doctrine will ensure that your ability to assert confidentiality or privacy as a right is reduced. Finally, I'll just conclude by one quote. Thomas Jefferson and my learned friend Mr. Bhatia says that the best protection against victimization is full transparency. So that just want to emphasize that. And finally, I would just like to end with a quote by Thomas Jefferson. He said, information is the currency of democracy. And someone added to that quote saying its non-disclosure should always be suspect. I'm grateful, Manoj.
Thank you. Yes, Mr.
I apologize for being on VC, Lordship.
Really don't give rejoinders, my lord, but I have no objection.
As an intervener, my lord, technically, right, my lord, let me, my lord, have something to add, my lord.
Lordship, I just wish to take 5 minutes for one of the petitioners.
Let Mr. Khansare conclude. Yes, Mr.
Please,
Khansare.
Just a minute. Yes. My lord, the two quotes which my learned friend, Mr. Solicitor, started saying, practicality requires that I contribute to political parties. Practicality required, these are my lord from the quotation because now we have the advantage of my lord YouTube and the transcript. Require I contribute with a degree of confidentiality so that I'm not victimized in future. Lord, this is the whole basis, my lord, of the scheme. Lord, my submission is, my lord, we are talking of political parties. We are not talking of rival groups who are collecting money. And the political parties fight election on the basis of their development activities, maybe on freebies, maybe on caste census, but not that we will victimize a political person, a person who does not pay us, at least who's paying someone else more. The whole foundation is, there is a confidentiality, otherwise there will be victimization. With great amount of respect, nobody is coming forward to say, the rival group will be victimized. The government is trying to justify it, with this contribution, with confidentiality. And the other justification is, my learned friend has some difficulty in using the opaqueness or, the anonymity. He said confidentiality. Very well, confidentiality of 100 or 1,000 corporate houses, would it not override the right of information of 140 people of this country, my lord?
That is already argued.
No, I have, my lord, what they said, my lord, yes, the confidentiality is the key, is the required. Confidentiality of 100 or 1,000 corporate houses is required. But, my lord, my submission is right of the citizens would override, my lord, overweigh the right of the donors. How can you say, my lord, the 140 crores people's right, I will not take into account. I'll take into account the right of the 1,000, my lord, or 100, my lord, or 5,000 corporate houses. Thirdly, my lord, the black money Mr. Sibal has given, I will give in a chart, my lord, of the RBI guide, my lord, from the RBI source. The amount of money was, my lord, in 18 lakh crore cash in 17-18 when the scheme was introduced, and today 22-23 it is 33 lakh crores. My lord, the details are given with the page numbers with a tabulated form in a chart to the court master. My lord, lordship would, my lord, just take into account, if your lordship to take that, my lord, the black money has not gone or cash money has not gone. Fourth, my lord, my learned friend Mr. Mehta said that what will happen is pre-2017 era. And he gave the figures from 2004 to 2014-15, where, my lord, he did not name, the BJP got 65% from undisclosed source. Presently also, my chart at page 59 says in my written submission, 65% is from undisclosed source presented by them. The same amount of undisclosed source remains, my lord, even with this scheme. And finally, my lord, as a citizen, I must say, my lord, that my learned friend Mr. Mehta said this was the best solution we found. As a citizen, my lord, the best solution would be no cash donation. My learned friend says digitization has gone in our country 9 times more than Europe and US together, 5 times more than China. Let there be no cash transactions, my lord, it will stop. Everybody would know it.
Thank you, Mr.
I'm extremely grateful to your lordship, lord, and it's
Yes,
very
Mr.
difficult for
Pasha.
me, lord, after 4 hours.
The last word for you, Mr. Pasha.
Thank you, Lordship. I apologize first for not being present in person. It was because of an injury. Otherwise, I would have been there before my lords in person. Lordship, just 2 very short points. With respect to funding through subsidiaries by foreign companies, Lordship, there has been an attempt to misconstrue the scope of my lord's order segregating issues. Now, the order that had been passed by my lords in which these issues had been segregated, my lords had said that the Finance Act 2016 and the Finance Act 2018 and the amendments it brought about to the FCRA will be placed before a separate bench. Lordship, now what was amended in 2016 and 2018 Finance Acts in the FCRA was the definition of foreign source to exclude from a foreign source those companies which had foreign investment. However, Lordship, I wish to point out that where we are, minus the electoral bond scheme, even assuming those 2 amendments to the Finance Act stand, is that each foreign source, whether there are 4 major sources through which foreign investment comes into the country, Lordship. One is foreign direct investment, one is foreign venture capital investment, one is foreign institutional investment, and one is external commercial borrowing. each one of these lordships, and I have placed the regulatory guidelines and the regulatory mechanism for each of these in my volume 4 along with my written submissions. So the FEMA external commercial borrowing 2000 regulation 2018, the SEBI FVCI regulations, the SEBI FII regulations, and the SEBI non-debt instrument regulations, all of which lordship cover ECB, which is external commercial borrowing, FII, foreign institutional investors, FVCI, foreign venture capital investors, and FDI, which is foreign direct investment. Lordship, for each of these, and I could point out the page numbers of the regulatory mechanisms and the schemes and the regulators who are appointed, but very broadly, Lordship, for FIIs, there is a complete disclosure required for the end use of the funds that come in, including which company they're investing in. That has to be placed before SEBI and the stock exchanges. Same for FVCI, foreign venture capital investors, which is also SEBI regulations, where SEBI is the regulator, and the regulatory mechanism requires a full disclosure of where the funds are being placed. For external commercial borrowing, Lordship, RBI is the regulator, and the external commercial borrowing regulations require.
We needn't go into this. Thank you.
No, Lordship, I just finished my sentence, Lordship.
Give them
Only
one.
one line, my lord.
Lordship, if it's not for the bond scheme,
Only one line, my lord, if your lordship permits.
Lordship, I'll just finish one line, Lordship, and I'm done with my submissions. If not for Lordship, if not for the
We would
electoral
like
bond,
Election Commission to get the data in accordance with the order dated 12th of April 2019 for the period ending 30th of September 2023. On 12th, ऐसा लिख लीजिए.
Only one line.
We have heard arguments on behalf of the contesting parties. Stop. Arguments are concluded and the judgment is reserved. Next, on 12 April 2019, an interim direction was issued by this court to the Election Commission of India. Full stop. The Election Commission has produced in a sealed packet, it's data as of the data in terms of the interim order as of April 2019. Full stop. The order of this court was not restricted to the date on which it was pronounced. Full stop. If there was any ambiguity, it was necessary for the Election Commission to seek a clarification from this court. Full stop. In any event, we now direct that the Election Commission shall produce up-to-date data until 30 September 2023 in terms of the directions, interim directions, which were issued on 12 April 2019. Full stop. This exercise shall be concluded, shall be carried out within a period of 2 weeks on or before K.R.L. The data in a sealed packet shall be handed over to the Registrar Judicial of this court.
Not only one line.
Lordship, may I conclude that thought, and Lordship will then see if it's
failing in my
relevant or not
duty if I don't say this. But I was little perturbed when Mr. Sibal said that there is no possibility of eradication of black money in this country. I am not that pessimistic. But the way in which digitized payment is increased, it is significant improvement, and the country should not be pessimistic. We are in the process, and we will eradicate black money.
Thank you, Mr.
Lordship, may I conclude
Thanks
just
to all
thought
the
in one
current
sentence?
counsels. Thank you very much. Thank you very much.
But one more suggestion, my lord. It's my suggestion. But despite, my lord, my saying about SPI, etc., if your lordship's conscience, my lord, is desires to be satisfied more, your lordships may consider RBI, which is a statutory bankers bank. There may be some administrative issues instead of SBI, because they may or may not have presence all over, my lord. This is just to show my bona fides. That's
Please, Alas.